connected to the killing of a 16-year-old girl. Brianna McMillan was shot to death Friday afternoon. As Stephen Cheetah reports, police now say she may not have been the intended victim.
Shortly before noon Friday, 16-year-old Brianna McMillan talked with a group of friends in the parking area of the Potomac Gardens housing complex. Someone opened fire in what police designated a drive-by shooting. McMillan, not the apparent intended target, was hit repeatedly and killed. Police now are looking for this man, 30-year-old Saeve Evans.
This is a very close-knit community. We work here, we try to do good, understanding it was a shocking event.
The police say they got their break from surveillance cameras here at Potomac Gardens. They say they clearly show Evans pulling a gun and shooting.
There were a number of people out there, and Saeve Evans discharged a firearm under those circumstances, which, in my opinion, is absolutely reckless.
Investigators won't say whether they believe Evans is the person who shot McMillan, but they do believe his arrest will prove vital to solving this case.
If he is listening and he has any conscience or any human decency, we ask that he turn himself in and take responsibility for his actions.
The shooting and other...
Yo, all right, today we got none other than Aunt Glizzy's big brother, man. His paperwork has been located and found and put on my desk. So today we're going back to 2016 and check out a homicide that he was involved in, man. If you have not done so already, hit that subscribe button. This is the start of a new week. We will potentially get more Foia requests with exclusive content regarding some of the Chicago cases that we all know and love, and all those people that we know and love. But today we have none other than a Washington D.C. native, man, the big brother of none other than Aunt Glizzy, man. There's a lot of speculation surrounding his name, man. I got a couple videos coming behind this, so you definitely want to hit that thumbs up and subscribe if you have not. Today we're just going to dive into some of the paperwork, not the whole thing, but you're going to get the gist of why he gets so much respect around DC, man. Here you go. Peace. McGarden shooting. Saeve Evans met up with friends, Brianna McMillan and Tajma Dockery, in the outdoor area of the Potomac Gardens apartment complex. The three smoked a joint while standing between a blue dumpster and a yellow donation bin right next to the complex's parking lot. Once the trio finished the joint, Dockery, who was 16 years old, walked into the parking lot where a friend was waiting to pick her up. A black Nissan then pulled into the parking lot and went straight toward Evans and McMillan. The car broadsided with its rear windows rolled down as if to give those on the passenger side a direct line of sight to Evans. Multiple gunshots then rang out, and it seems that some were fired by the occupants of the car and some by Evans. One of the shots struck McMillan in her head and killed her, though it was unclear who fired it. The black Nissan then backed out of the parking lot and drove off and was later abandoned nearby. It was outfitted with counterfeit plates. Neither Evans nor any of the car's occupants called 911 to report the shooting. Dockery had ducked and closed her eyes when the shooting began, looked up when it stopped, and saw that McMillan was dead. Dockery testified that she was scared, her adrenaline was pumping, and she was disoriented. She testified that Evans, too, looked scared. His eyes were wide and his breathing was heavy. Dockery immediately asked him, "Did you do that?" Evans replied, basically yelling, "No, they did that." And he then took off running. Surveillance footage captured Evans holding the gun as he ran from the scene in the seconds after the shooting. But there was no evidence of what he did with the gun once out of frame. 3 surveillance video cameras captured the events in Potomac Gardens from different angles. One camera showed the black Nissan entering the parking lot, driving towards Evans and McMillan with its rear windows down, then broadsiding and pausing for a second or two. The car then promptly went into reverse and backed out of the entire length of the parking lot within a few seconds. The other 2 cameras show the area behind the blue dumpster. At some point after the shooting, at some point after the shooting started, the footage shows Evans walking backward, pointing and seemingly firing a gun toward the parking lot, and then removing the magazine from the gun and running away, carrying the gun and magazine with him. While it is difficult to pinpoint just how long after the shooting ended that Evans can be seen still in possession of the weapon, it was about 3 seconds, or roughly the same amount of time it took the black Nissan to back out of the parking lot. 16 cartridge casings were found on the scene, mostly concentrated around where Evans was standing. The government presented an expert who testified that 12 of the 16 cartridge casings recovered came from a single gun, though he could not say the same of the other four. There was further evidence that both the black Nissan and the dumpster that Evans was standing near showed signs of damage from gunfire. More specifically, metal fragments that surrounded the dumpster and a nearby clothing bin looked like fragments from bullet strikes and small marks on the parking lot facing side of the dumpster, and a window behind the dumpster appeared to be strike marks caused by bullets. The police ultimately tracked down and spoke to the black Nissan's owner. After multiple interviews with her, she maintained that she lent her car to someone on the day of the shooting, but refused to identify that person and refused to give the police consent to search her phone so they could attempt to identify that person. It does not appear that officers ever identified the car's occupants. The police did, however, obtain a warrant to arrest Evans within days of the shooting, and he turned himself in shortly after the warrant issued. While in jail, Evans had two phone conversations that the government introduced as evidence at trial. First, Evans spoke to Dockery over the phone. During the call, he said, "You know what time it is," which Dockery took to mean that Evans knew she would have to testify because she was the only person with Evans and McMillan the day McMillan was killed. Dockery testified that she did not feel threatened by the phone call. In fact, she thought Evans could have been trying to tell her that he didn't blame her for testifying. Second, Evans called a friend and suggested he wanted to give the friend the ice because one of us might as well look sweet. The government maintained the ice referred to a gun, while the defense countered that it was more likely reference to diamonds or jewelry. The trial proceedings. Evans was charged with first-degree murder while armed. DC Codes 22-2101-4502 and 3611. A second-degree murder while armed. DC Code possession of a firearm during a crime of violence, and possession of a firearm by a person previously convicted of a crime punishable by imprisonment for a term exceeding 1 year, felon in possession. He was also charged with 2 counts of obstruction of justice in violation of DC Code 22722A2A, A6. The evidence at trial was largely undisputed. Evans did not dispute that he shot at the car and that he held the firearm for a few seconds after the car had started backing away and as he ran off. The central dispute was whether Evans had acted in self-defense. Evans argued that the occupants of the car had started shooting at him first and that he had returned fire only in self-defense. The government maintained that it was Evans who shot first because he believed that a man named Son Schuler was in the car. Schuler had shot Evans at least 16 times 4 years before the Potomac Garden shooting. In that prior incident, Schuler exited, in the government's words, a black car similar to the black car in this case, just before shooting Evans. Schuler was incarcerated for that shooting, but he had been released to a halfway house mere days before the Potomac Garden shooting, and the halfway house's record showed that Schuler had left the house about an hour before the shooting in this case. The parties unsurprisingly focused their evidence and arguments on the murder charges and the claim of self-defense, with virtually no attention paid to the FIP charge that now lies at the center of this appeal. The government gave the FIP charge only brief attention in its closing argument. It argued that the ice Evans mentioned in his jail call referred to a gun and showed that Evans still had the gun after he was arrested. Defense counsel countered that the only evidence you have in this case of Mr. Evans possessing a firearm is evidence of him using it during self defense. And since there is no evidence of him carrying that gun at any point in time, other than the time of which he was being shot at, he is entitled to, has a right to, and is not guilty because he did so in self defense. In its rebuttal, the government argued that Evans must have had the firearm prior to the shooting because it would be implausible to believe that Evans had, by random coincidence, found a firearm on the ground just as he needed to use it in self defense. The government also argued that Evans was guilty of FIP because even if you were to consider self defense, having a gun outside that narrow frame that takes it outside of self defense to now possession. The jury's note and the court's response. The trial court instructed the jury on the elements of each charged offense, including the FIP charge. After doing so, it read criminal jury instruction concerning Evans' defense to the FIP charge, namely that his possession came in course of lawful self-defense. That instruction states in relevant part, when a person picks up and uses a firearm during the actual exercise of actual self-defense, that person is not guilty of unlawful possession of a firearm during the period of actual self-defense. On the other hand, if a person unlawfully carries or possesses a firearm and then at a later time uses it in actual self-defense, that later lawful use does not make the earlier carrying or possession lawful. Likewise, use of a firearm in actual self-defense does not make carrying or possessing the weapon lawful after the time of actual self-defense. On the second day of deliberations, the jury sent the following note seeking clarification of that instruction. Self-defense does not excuse possession after the time of actual self-defense. How long after? A reasonable period of time to ensure that the danger has passed, or some other standard. The trial court asked the parties for their positions as to how it should respond to the note. The parties responded with their proposals first via email. Defense counsel's email response was that if a person picks up and uses a firearm only in self-defense, there must be some reasonable period of time after the use of the weapon in self-defense for the defendant to be able to dispose of the gun before it becomes unlawful. Citing Rosamond versus United States, defense counsel elaborated that a person must have sufficient knowledge to allow them to make the relevant legal and indeed moral choice after the need for self-defense has ended, and that they must have a realistic opportunity to quit the crime. To capture those principles, the defense proposed the following response. Where a person uses a weapon in self-defense, self-defense does not excuse unlawful possession of the firearm for such a reasonable time to ensure the danger has passed and for the defendant to regain his composure so as to make a decision about how to lawfully dispose of the firearm. The government objected to that answer and proposed the following alternative. The defense is limited to the time in which the weapon was needed in the immediate exigency of self-defense or defense of others. It is not available before or after the time of actual self-defense. The parties then returned to court to address the topic within minutes of their email responses in court. The judge proposed the following answer, largely aligned with the government's proposal, but exercising its immediate exigency language. With respect to self-defense, the possession of the firearm can be considered to be innocent only for the duration of the need for self-defense. The need for self-defense is present so long as the defendant actually and reasonably believes at the time of the incident that he is in imminent danger of death or serious bodily harm. The judge stated, I think the government is right that the need for self-defense is present only so long as the defendant actually and reasonably believes that the weapon was needed to prevent death or serious bodily injury. It then invited defense counsel to explain their contrary view, asking, what is that a misstatement of the law? Why is that a misstatement of the law? Defense counsel then reiterated the legal position that they had already taken in their email. They restated their view that you can't be guilty of a crime unless you have the realistic opportunity to form the mens rea of it, and that it would not make sense to require somebody to just drop a loaded gun in the street the instant they the instant they recognize the threat has subsided. They continued that Rosemont instructs that a person has to form the intent and then also have enough time to come down from the. Before they could complete that thought, the court interrupted that it was not going to give that proposed response because those instructions are already there. There are instructions about reasonableness and perception. I don't want to repeat every other instruction. The court then pivoted to the government's request to tell jurors that possession could be only for the immediate exigency of self-defense, positing instead that how long the period of exigency existed is a determination that the jurors make. Defense counsel said, I don't object to that. The bulk of this subsequent discussion was focused on the government's request to add immediate exigency language to the court's re-instruction. The government thought it critical to inform the jury that any justified possession for only a very finite period. The court rejected that proposed addendum and added a different concluding sentence to its proposal, returning to the idea that it was for the jury to decide how long the defendant might reasonably believe he was in imminent danger, but still providing the right to possess the firearm in self-defense lasting longer than that. The court's proposed response read, with respect to self-defense, the possession of the firearm can be considered to be innocent only for the duration of the need for self-defense. The need for self-defense is present so long as the defendant actually and reasonably believes that he is in imminent danger of death or serious bodily harm. It is up to you to determine the length of time for which the defendant could reasonably believe that he was in imminent danger of death or serious bodily harm. Before re-instructing the jury, the court asked whether this response was agreeable to the parties. Both parties said it was fine and lodged no further objection. The court confirmed this is without objection from either side correct. Both parties agreed. The court then answered the jury's note as set forth above and sent the jury back to deliberate. About 45 minutes later, the jury returned its verdict, convicting Evans of FIP and acquitting him of all other charges. The court sentenced Evans to 56 months imprisonment, followed by 3 years supervised release. Evans now appeals. All right, I appreciate y'all for tuning in. Let me know what y'all think about this down in the comments, man. And Glizzy's older brother, we just went through this. This is coming through from DC, man. We just left Chicago, coming to DC. Who knows where we'll go next, man. If you haven't done so already, hit that subscribe button and thumb up the video. We are on the road to whatever the K is next. I think it's 4K. Then we're on 5 to 10 and so forth. So you want to go along for the ride. Make sure you hit that subscribe button if you have not. And definitely thumb up these videos. And if you haven't seen some of the other videos that I've done, I'm working on getting end screen set up and stuff like that, so I can show you guys, highlight some of those videos at the end of some of these videos. So, but thanks to you guys for watching today, and let me know what you guys think of this. Peace.